Great. And I'm sure even if you didn't watch from when it was happening, you are now apprised of some of the things she said at that press conference. What are your impressions first of all?
Well, first of all, my first impression is that that conference was needless. Number two, at the end of the day, it demonstrated to that perhaps, with all due respect, the Chief Justice demonstrated, and it is alarming because you can't have that as a Chief Justice or even a member.
Lawyer, you have to. I lost you there briefly. You said it demonstrated two things, but
Yes.
just when you're about to mention them, I lost you there.
Okay.
Yeah.
I said she demonstrated two things. First of all, I said she demonstrated lack of fundamental principles of law and procedure, and even understanding of the procedure under Article 146. And that is alarming because you can't have a Chief Justice demonstrating lack of basic principles of law and demonstrating lack of understanding of the purpose of the Constitution. So it was needless. The conference was needless. What was it supposed to achieve? It appears he wants Ghanaians to know that she is a victim of some persecution. But that is needless because the process itself, the outcome of the process itself, will either vindicate you or otherwise. Ghanaians have witnessed the kind of justice that has been administered in the court. And the second thing is, there are so many inaccuracies that she had referred to in defense of herself. I understand that she wasn't giving the petition, the copy of the petition. I don't know if I'm right, but
Yes.
listening to you now, it appears she is saying that the one given to the committee is the one she demanded.
She wanted, yes, yes.
So it's not like she wasn't giving the petition at all.
Yeah.
She was giving, but she wanted to know
what the committee has.
Yeah. But the point is this: the committee is inquisitorial, and though we can say that investigation or inquisitorial process can also be described as quasi-judicial, it is not the petitions that now determines what happens at the end of the day. It is the evidence that is being led and the defense and counter evidence that is coming from her that will determine the outcome. And there is no way that it will be hidden if the committee rely on something completely different to now give a recommendation to the president for whatever they want to recommend. It will come out because they can't use evidence of one petition to support evidence of a completely different petition. You cannot use the evidence of one claim to support another claim, which is different from the other claim. It is not possible. For instance, if I make an allegation against you that you have committed assault, and then I take evidence in respect of assault, how can I use that to support an allegation of stealing? It is not possible. So I don't think what she is requesting is here or there. But as I said, it's unfortunate. For me, the press conference is needless. This is not the time for her to demonstrate to Ghanaians about her inclination or her commitment to judicial process and to principles of justice. No, she had that opportunity when she was sitting there, and Ghanaians saw what she did, and that is what Ghanaians will judge her by. It is not what is happening to her now. It is what he did when she was sitting there. All right. Now, I had an opportunity somewhere to comment that I was actually alarmed and very, very, very surprised that the Chief Justice was alleging that he was not giving a copy of the decision of the prima facie case, so that, and that demand was in the nature of a prima facie determination that ought to be in the form of a judgment with reasons. So it's like she required a decision, a well-reasoned decision with reasons, why the prima facie determination was done. You see, but what you do, life is just like a mirror. It reflects what you do. I have evidence about a case that I was involved, and this Chief Justice spoke like an oracle. No reasons whatsoever. After reading dossier of written submissions from myself and from Attorney General, she used one sentence to determine the matter. No reasons, nothing whatsoever. She spoke like an oracle. We find no merit in this application, and we hereby dismiss it. And she did that right in front, in the proceedings, without rising up into chambers to consult the other judges. This is something I personally experienced. I have nothing personal against her. Let me make that clear. In fact, I agree to the aspect, the claim she made, that she is not corrupt in terms of bribery in private matters, in private litigations. That I can attest to. I mean, private litigations, taking bribes. No, I cannot say that, knowing her and doing cases before her. But you see, we are judged. This process is about her conduct as a Chief Justice and as a Supreme Court judge. Now, when you are in the Supreme Court, there are other avenues of corruption that is not limited to bribe taking. When you have some kind of disdain for, or some kind of love for a particular ruling government, and everything of it seems to be right and everything against it seems to be wrong, that should not be the mindset of a Chief Justice. You see, so the context of this process is about what she has done while being there. It has nothing to do with taking bribes. In fact, I'm not sure if any of the petitions allege bribery against her. And so some of the things she actually made reference to in the press conference, to me, are irrelevant. And secondly, some are inaccurate. But be that as it may, my impression is that it's needless. It demonstrates, it tells us. In fact, I made this point earlier on one of my public media encounters. I made it when she filed this application in the Supreme Court seeking the enforcement of her fundamental human rights. And I was like, wow, a Chief Justice seeking to enforce her fundamental human rights herself in the Supreme Court. when the Constitution has given that exclusively to the High Court? So I was like, what do we have? So all this was, I said, this process is about your competence and misbehavior or misconduct. So if it fails on one ground, they might be able to stand on the other. And you are busily demonstrating what I personally see as incompetence. How can any Supreme Court judge, let's even say the person is not a Chief Justice, how can you take enforcement of fundamental human rights personally to the Supreme Court? The law is clear that High Court is the only place you can enforce fundamental human rights, except that it is not a personal application you are making. Someone else who is public spirited wants to enforce another person's fundamental right, human rights. As a J. Ample for this, in respect of the people who were made to carry latrines of human excreta. And he said, well, this is so that you can go to the Supreme Court. But you yourself, personally, you are the victim of what you allege to have happened, and you are approaching the Supreme Court with it. I found a lot of incongruity with somebody's capacity to be a Chief Justice or even a member of the Supreme Court bench, to be honest.
That's quite interesting. You're saying that so far, watching her moves, and the kind of reasoning you've heard from her is raising questions about her competence to be there?
Of course, yes. Hey, that's why I'm saying, Senna, I have nothing personal against her. But trust me, if lawyers were made to elect a Chief Justice, it wouldn't be her. Because we know the judges, we appear before them, we know their capacity, we know their depth of law, we know their grasp, their wide, the width of their knowledge. We know them. I don't think she's one of them. It's just by, providence that if lawyers were to elect a Chief Justice, trust me, it won't be her.
See, that's a very serious statement to make.
But yeah, I have a right to give my opinion about it.
Well,
I have a right to give an opinion about it.
Because some of the things she's complained about, that courtesies that are supposed to be extended to a Chief Justice are not be extended to her, including being thoroughly searched before committee work. She wants her family members at the committee. Then she also goes to the Edu Lodge matter and how it's traumatic to her because of her history, and her uncle, who was one of the people who were killed as part of the judges who lost their lives, I think in 81 or something. And she talks about not being given copies of the petitions, among others, that she's also heard that the committee has permitted the petitioners not to testify. Among you say all this are needless?
Why? You see, the committee reserves the power and the authority to determine what is relevant to their scope of operation. It is not every evidence or every information we take just because an allegation is made. She knows that as a judge. They have the power to eliminate even irrelevant evidence that is irrelevant to the allegations that are made. So point is, if the committee finds that the information that whoever has already put in a petition, for instance, even in civil litigation, in pleadings, there are certain things the plaintiff or the initiator of the action is not entitled or is not obligated to prove. And one of such is those allegations that are admitted. If you make an allegation and it is admitted by the person against whom you make it, you are not obligated to adduce any further evidence in proof of it. And if you make an allegation and you back it with, let's say you make a reference to a document and you back it with a document. You back it with a document. Of course, they might want to cross-examine you on that document. You see, so the committee also, that's why I said sometimes our shadows chase us. And shadows are a reflection of us, aren't they?
Yes.
We were here when the Supreme Court told us that they couldn't compel Jean Mensa to go into the box and give testimony. Do you remember that?
Yes.
Yes, I didn't agree to that. Legally, it's not correct. Legally, it's not correct. A court, and that distinct from a committee, I will make the difference. But a court has the powers to subpoena someone, which means to compel you to come to court and give and testify in different circumstances. A court can order someone who is sitting in court to tender a document or come and testify. And if you refuse, it constitutes contempt of court. The court, you see, many people think that they sweepingly state that, Ghana is an adversarial system. It's an adversarial, so there's no inquisitorial. There are inquisitorial elements in our legal procedure. Anybody who says that is not actually cautious to look at our legal procedure. So I agree that in the committee, some of the committees have the powers of High Court to compel someone to come. I am not sure if this committee under Article 146 has those powers, because it's not stated under. But committees under the Constitution, commissions of inquiry under the Constitution are always giving that power. But let's even assume that they have to compel someone. The Supreme Court has earlier told us that that power is non-existent. They couldn't compel someone who has filed a witness statement. And the rules say if you file a witness statement, you must come and testify. But they say no, they couldn't do it. So why all of a sudden, if the Supreme Court has properly constituted, does not have power to compel someone to enter the box and testify and be cross-examined, how can a committee under Article 46 do that? And always, let's remember, the law may be wrong, but until it is changed, that is where it is. That is what the law would be. You can express all the adverse opinions against it, but our opinion as lawyers, or our opinion, will not shift. It may only contribute to future changes or development of the law, but the law will remain as it is. So if the Supreme Court says there's no power of compulsion for any judge or any judicial authority to compel someone to enter the box and testify, why are they arrogating that to a committee? And secondly, it might be that whatever the petitioners need to come into the box to say, perhaps is not relevant at that stage of the proceedings. But I don't want to wade into that because, of course, the petitioners must be cross-examined. For me, if you make allegations against someone and you even adduce evidence, you still can be cross-examined. But you see, it is not a completely judicial process. This is inquisitorial. The committee is tasked to investigate and take information. Investigation can also be either open or covert. But of course, if it affects a person, you need to give the person an opportunity to be heard in respect of it and also avail the person the source of the information against it for the person to be cross-examined. That I agree. But generally, I think that we don't know enough to judge the process because it's in camera and it must be in camera. It must be. And so these vestiges of the proceedings being thrown out there in the first place is illegal. It's unconstitutional. You shouldn't be talking to us about what is happening in the proceedings of this nature because the Constitution mandatorily requires that it be in camera. And being in camera means it should be confidential. It should be hidden. It shouldn't be public. So why would the Chief Justice of all people be the one to do things that are affront to the provision of Article 140?
Because having listened to her, there was only one opinion. Because if you listen to even Phyllis Kwache's responses, it was about whether there was a political agenda against her. But there is no discussion around the real things that are happening because she has told her side of the story. Should we be also demanding that the people who are handling the thing respond to her?
No, you see, I also have another opportunity to say somewhere that let's assume that there is some motive of political persecution against her. Assuming that's correct. Senna, if someone wants to do something against you, let's say at your workplace you have rules of conduct, and someone thinks that, okay, the rules prescribe certain conditions for dismissal, and you are not guilty of any of those conditions, but the person desires that you be ousted from your office. Can the person do that? No. Can the person do it if you haven't done anything that satisfies the legal prescription for dismissal? Can the person's desire actually take you out?
No.
No. That's why I'm saying that. You see, they should stop politicizing and sensitizing the public with political motives. Allegations are made. Face the allegations and come out clean. It is possible that you can face the allegations. But you see, if you leave the allegations and you claim that it is a political persecution, there's a motive to oust you from office, where is the evidence for that motive? The evidence for that motive anyone or any person can point to is the fact that the proceedings are going on. But the proceedings are also constitutional. The Constitution hasn't created any office to be perpetual. The Constitution hasn't made any employee of government or the state to be perpetual. The Constitution has given safeguard protections for certain offices, and of course the judiciary is one of them. But the same Constitution says that a justice of the Superior Court or the Chief Justice can be removed based on grounds, 2 grounds, or as I say 3, but 2 are relevant here. stated misbehavior and incompetence. You see, the other one is when you are incapable of performing your function because of either physical or mental disability. That's not relevant here. The two are incompetence and stated misbehavior. So the allegations, if people are making allegations of stated misbehavior, allegations of incompetence, yours is to face the allegations, either to prove that what they are calling incompetence is not incompetence, or what they say you have done to constitute incompetence, you haven't done it. That is the crux of the matter. That's the crux of the matter. So, but if at the end of the day, you rather want to approach the public instead of the committee and sensitize the public and let them feel that you are a victim of persecution, and in that process, you are demonstrating to people of knowledge that you are actually incompetent, you are worsening your own situation. Because ask anybody that no lawyer would go to the Supreme Court to enforce personal fundamental human rights. No one will do that. No lawyer will do that unless you don't know your law properly. But the Chief Justice has done that. So that's why I say it's needless. Look, her silence would have been the most powerful weapon. Just be silent and go through the process, even if at the end of the day you are removed. Posterity will vindicate you. Today, as we speak, how do you see Charlotte Osei? Yes, because she was quiet and submitted herself quietly through the process. Today, people think that she is vindicated. I wrote a whole article about the removal because the standard set for the removal of someone in a protected office as that, to me, were not met. Were not met. A person in such an office can commit a misconduct. But it is also important for us to weigh the conduct and see whether, even if it is true, it meets the threshold required by the Constitution to call for the person's removal. So, in the case of Charlotte Osei, I said, granted that procurement breaches were made, do they constitute sufficient grounds for her to be removed from office? Or we need something more grievous? But the previous administration thought that, okay, let's set the standard here. Breach of the law. Breach of the law is sufficient for removal from office. Here, we have allegations against the Chief Justice in her administrative capacity, applying some funds to herself and her family, which were not meant for that purpose. That's the allegation being made. And if that is true, it is not only a misconduct, but it's also criminal. And you say, instead of facing this allegation and proving that, in fact, if what I saw was actually the response, she admitted that was done, but it was because he was entitled to another provision of her 10 conditions of service. So, in the first place, you have demonstrated a misunderstanding of your own conditions of service. If the response and the allegations are anything to go by, it is a demonstration that you don't understand when to apply what, in what, or to what. Because they've given you conditions of service. There's one you can travel with a security. There's one you can travel with your family. Then you apply the other one on the other. That's what I saw. And you admit to that, and you claim you are entitled to do that. You see, so those are the issues in all humility. These things we are talking about, we shouldn't have even been privy to them. But for her conduct, you don't take these things out. This procedure is covered in order to protect your reputation. Whatever you have done, whatever the committee investigated would have been a secret. No one would have known anything. But now things are coming out and showing that, okay, these are the allegations made against you. These are your responses, and everybody can read the response and the allegations and all that. So even if all the allegations made against her are false, but this particular one is true, it still can constitute a grounds because it is stated misbehavior. You can't misapply your terms and conditions of service as if what's alleged is true. And misapplication of it can qualify as stated misbehavior. Now, in addition to that, they are alleging some incompetence. That you are not competent to be a Chief Justice. And they have made allegations. So face those allegations. Those are the crux of the matter. Because if at the end of the day, stated misbehavior is proven or incompetence is proven, then Article 146 of the Constitution is met. And whether there is some political desire or hatred against the process, it will yield the required results that the Constitution intends. No political motive will change the outcome if what the Constitution prescribes is met. And no political motive can change the outcome if what the Constitution prescribes is not met at the end of the day. If at the end of the day it is proven that indeed he didn't misapply the terms of and conditions of service, and all the allegations they made do not constitute to incompetence, that's it. No matter your motive, if these things are not met, she remains the Chief Justice. So for me, I think she should stop wading into politics and even insinuating. You see, the statement made about even the venue, high security place. Why wouldn't it be security place? It's for her own good. In any event, the situation, the venue is such as to enforce Article 146 requirement of it being confidential. What's wrong with that? And then I hear something like, my uncle was murdered where I am being tried. Oh my God. So, killed by who? Killed by who? Murdered by who? This is a serious allegation that has been made. Has anybody been tried and convicted on the murder of her uncle? Does she have any evidence that her uncle was murdered there?
No, the point she made was that the Edu Lodge was part of the planning that led to the murder of the judges, in which her uncle, who was a military officer, was also killed.
No, say that again.
I'm saying that she says the venue currently was part of the planning that led to the killing of the judges, during which her uncle also lost his life.
So which means that was the venue they planned to kill her uncle.
Yes.
Does she have evidence of that? because these are bundle of allegations that my uncle was murdered by someone, and this is the place the person, along with others, planned to kill him. Do you have evidence of that? And who killed him? So these are all sentiments that are inbuilt in our Chief Justice. Definitely, the situation she's referring to is capable of making some people, of making her adverse to some people. Do you understand what I'm saying?
Yes.
Yes, it is capable of making her adverse to some people, or creating hatred for some people, against whom justice from her might not find a way, or to whom justice from her might not find a way. If you hate someone, how can you administer justice to the person?
You're saying this exposes her own prejudice?
Yes, prejudice against the people he perceives or she perceives to be the killers of her uncle. We don't know them. And we don't know how he got to know them. And we don't know what he knows. What if she thinks that you and I are part of it, and we appear before her for justice? Do you think we'll get it? So these things are needless. In all honesty and humility, and as I say, let me keep repeating, I have nothing personal against her. In fact, I used to like her as a judge.
Oh, you used to?
Court. Yes, I used to. Until I saw what she was demonstrating in the Supreme Court as a Chief Justice and as a member of the Supreme Court bench. I used to admire her a lot, because truly, from what I know, she was incorruptible in private litigation. But she betrayed all that when she got to the Supreme Court. Why? Because cases in which I am personally involved demonstrate to me that no, this was not justice. And as I said somewhere, justice is not taught anyone. Everybody knows what justice is. It is intrinsic. Even if you don't go to the law school, even if you have never learned any principle of law, if someone is unjust to you, you will know.
Right. Thank you. Yes. Thank you very much for your time. Of course, you've notified me that you're supposed to speak somewhere else. So thank you.
Most welcome.
Yeah. He's a private legal practitioner. His name is Alhassan Osman. Join us on the line, sharing his thoughts on what we heard from the Chief Justice. Suspended Chief Justice yesterday. Listen, he seems to be smiling. You see, the interesting thing is that I think the more she speaks, the more she exposes a lot about who she is. And if I were advising her, I would say keep quiet. Let your lawyer and you face the what do you call it, the allegations. If there's nothing against you, nobody can force something to be there when there's nothing there.
Yes.
So like lawyer Osman says, no political motive can change the outcome of what is supposed to be the standard set by the Constitution. If they don't meet the standard set by the Constitution, there's nothing that can be done about it.